In this lesson, we will understand how to protect your assets, what amount of assets it is good to protect, where to go to secure your assets. This is regardless of why you want to defend your assets.
The basis of asset protection, as you may guess, is always the presence of a more or less extensive asset to protect. The question that is asked again and again is what is the starting sum from which we can begin to establish a course of action to protect it from external aggression. I make a necessary premise, let us not give benchmarks in terms of assets and in terms of aggression, because to do so might exclude some kind of situation that in practical reality must instead be included.
Conversely, I give an example.
Let me give an example. External aggression can arise from any situation. Let's talk about the classic aggression from a creditor who advances money from you for any underlying reason. Let's talk about an aggression that perhaps can occur as a result of a separation in the marital sphere. Now, whether it is the husband with the wife or the wife with the husband, it matters little. The reasons why you might feel the need to resort to an instrument to protect your assets are innumerable, not the least of which are the so-called assets, a government especially in the wake of momentary crises, such as perhaps is feared to be the current one as we speak at the European and world level, which is plunging many of the governments of other countries into concern, fearing a possible energy crisis from which should then ensue a series of issues related to energy supply, price crisis, raw material shortages, and so on. All of these concerns may eventually lead a state even to proceed with a forced withdrawal of residents' current accounts. So for all these reasons, there are countless asset protection tools that you can implement, but they are of course not tools to be used without a careful case-by-case examination. Anyone who tells you that there is a single tool that can apply in any situation is lying to you, of course. Each case has to be evaluated on a case-by-case basis, which is why people pay professionals like us precisely to proceed to an all-round examination of their individual situation, and then from there structure an asset protection design. The minimum amount of assets to be able to proceed with a guardianship is difficult to say, because not all assets are liquid assets, that is, made entirely of cash. Paper money or any forms of cash that perhaps can also be cryptocurrencies, albeit with the appropriate distinctions that the law requires to be made. But other assets can be of an illiquid nature. We are talking, for example, about real estate, registered real estate such as the car, the boat, the private jet for those who have it, and so on. Each of these, beyond their economic value, imposes a consideration of the particular protection with respect to the individual situation that goes to be framed differently depending on of the person or persons of reference. So there is a heritage that perhaps, although it is at a lower liquid level than another, but is easier to protect or is more deserving of protection than a heritage that perhaps is larger, but because of its specific conformation does not require the same instruments of protection that perhaps can be discerned for those who have smaller heritages. I again give the example of those who have large heritages of precious stones, paintings, ancient relics, or ancient artifacts that have an increasing or less devaluing value depending on the situation or depending on the markets. But in each of these examples, the possibility of proceeding with effective asset protection is always there. Of course, for smaller assets, additional thought is required before proceeding with careful and instrumental planning for the purpose of protection. This is because of course the costs of being able to proceed with effective asset protection are of course numerous and are of varying magnitudes depending on the type of instrument one is trying to place or trying to promote or trying to obtain. Given that those costs in order to achieve effective protection have to be incurred and are in many ways ineliminable, in many ways not even the responsibility of the professionals who are following you, they have to be taken into account as if they were forced costs. And as far as smaller assets are concerned, you have to look at whether the size of that asset, which could be even a short asset in its current state, but one that is bound to revalue over time, I give the example of works of art, cryptocurrencies, or at least a part of them, which of course may be worth X today, and therefore for them the asset instrument may be excessively onerous considering the current value, could not be considered excessively onerous considering the revaluation or presumable future revaluation of the same asset and the same asset. So you have to take all these aspects into account. If we are talking about excessively small liquid assets, know that there are costs that you will have to forcibly incur when you want to proceed with estate planning or protection, other than the basic one there of simply opening a bank account abroad. Because many people are convinced that this is the only realistic protection that you can get, is also the most effective, which is absolutely not true. But what you absolutely have to take into consideration are the magnitude of these costs in a long-time view. Let me give an example. If you want to donate corporate assets to one of your foreign entities or an entity in which you have a qualified interest, this transfer of shares always happens for a certain price. It never happens for free. The transfer of shares to a foreign company inevitably involves, according to the Consolidated Income Tax Act, the TWIR requires the transfer by capital gain credit in the case of a foreign share transfer, which means that if you contribute shares, because assignment is still another legal instrument, but if we are talking about pure contribution, this contribution imposes on the one who makes the contribution of his personal shares to a foreign company the collection, at least in a completely theoretical line, of a capital gain on which a fixed 26% tax will have to be paid, according to the rules of the Italian government. There are, of course, ways in which you can avoid, in this particular case, an outlay of this magnitude, which I suppose for those who own small assets and do not tend toward the long-range view in protection can turn out to be what is vulgarly called a bloodbath. If instead you reason from a long-range view, you might keep in mind that these kinds of activities are necessary and prodromal activities for effective and proper protection over time. But even where it would be possible in the specific case to be able to try to avoid incurring an outlay of this magnitude, know that this is something you cannot do on your own, and you must always have a qualified professional by your side to show you what are the correct steps you can take in order to be able to avoid having to either pay taxes where they may be unpaid, or to have you pay the correct measure of taxes, where it can be achieved in the particular case.
Properly planning your asset protection, having proper asset protection, then doing it in the right styles and having on your side professionals who do this have helped other entrepreneurs, other people like you, to protect their assets. From our field, we can put our professionalism, our experience and our expertise as lawyers with accountants behind us who work with us. If it is help in asset protection, professional help, what you need, you can turn to our official channels.